punishment reads, we, the jury, having found that the defendant, Joshua Patrick King, is guilty of the offense of aggravated assault as charged in the indictment, now return this verdict as to his punishment. 1, we assess this punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of blank. It will be between 2 and 20 years that the foreperson will put into that blank. 2, in addition, we assess in either check 1, A, no fine, or B, a fine of blank. That will not be more than $10,000. 3, to be answered only if the jury has assessed 10 years confinement or less. We find the defendant has never been convicted of a felony in this or any other state, and we make the following recommendation on his application for community supervision probation. A, B, C, and D. I'll read those to you. A, we have not assessed a fine, and we recommend that the term of confinement we have assessed be suspended and the defendant be placed on community supervision. Or B, we have assessed a fine, and we recommend that only the terms of confinement we have assessed be suspended and the defendant be placed on community supervision. Or C, we have assessed a fine, and we recommend that both the defendant's term of confinement we have assessed and the obligation to pay the fine we have assessed be suspended during his good behavior on community supervision. Or D, that the defendant's application for community supervision be denied. The foreperson will sign that form. State, are you ready to give your closing argument?
Yes, sir.
You may.
Thank you very much for your attention over the past few weeks. I just want to make sure that you understand the law in this case before I have another chance to talk to you at the end. In this case, on the verdict form, you first have to assess a term of confinement. It has to be between the term of 2 years and 20 years in the Texas Department of Criminal Justice. You also do have to select a fine. In this case, one question that I often get from jurors is, does this fine go to the victim? I want to make sure that you understand it does not. Regarding this right here, I just ask that you do what you think is appropriate and just, whether or not a fine is warranted or not. You also do have to make a decision whether or not you want the defendant to have community supervision or not. The only way that you can recommend community supervision is if you put a term of less than 10 years or less. If you do decide to grant the defendant community supervision, I do ask that the underlying sentence be 10 years. And the reason for that is over the course of this community supervision, the defendant would have that possibility of 10 years of going to prison over his head during the entire term of that community supervision to keep him in line, to make sure that he follows those conditions. If he doesn't follow those conditions, a judge at a later date will decide to sentence him up to that term or potentially, based on these types of violations, to a lower term. Thank you very much for your attention, and I'll see you again.
Sets?
May I have a second, Judge?
Yes, sir.
Thanks, sir. Hello? It's up. Thank you. Good morning, ladies and gentlemen of the jury. Justice and mercy. You can do both. You could have something that is just and be merciful. Just to protect the community, to punish Josh. Merciful to show mercy towards Josh. You could do that. And you do that by imposing a term of sentence between 2 to 10 years. You impose a sentence of 2 to 10 years, and then you probate it. You put him on probation. The judge has taken judicial notice that Josh has never been convicted of a felony in this or any county or state. He's a candidate for probation, and we're asking you to be merciful and put Josh on probation. That's how you're just and merciful, by putting Josh on probation. Now the question is, why should we be merciful? Why should we be merciful? Another primary person who was affected by this is Mr. Rodriguez. And you heard from Mr. Rodriguez. What did he think about this? What did he say? I did not want Josh to be put to the ringer because of a mistake. Mr. Rodriguez himself characterized this as a mistake. Mr. Rodriguez forgave Josh. He forgave him completely. He forgave him wholly. Mr. Rodriguez, his thing was he wanted to live and let live. He wasn't here yesterday for punishment. He's not here today. He didn't come in here saying, like, you know what, I want my pound of flesh. You never heard that from Mr. Rodriguez. The actions that he had were actions of mercy. By putting Josh on probation, he will be doing that. He will be showing the mercy that one of the primary people in this case was showing towards Josh. Josh doesn't have any criminal history. For 20 some odd years, not a blip on the record as far as Josh being a dangerous, a bad person, nothing. May 22nd of 2020, from then this way, for the last 4 years and 3 months, zero. He's complied with the law. He's done everything he had to. If there was any evidence that he had not complied with the law, that he had possession of firearms, that he had been drinking alcohol, you would have that evidence before you. There's nothing. One mistake as characterized by Mr. Rodriguez. Why should we exercise mercy? The facts of this case. The facts of this case, this is not an individual who went out and just started looking for trouble. He didn't say, like, I have a gun and I'm going to go victimize somebody. That's not the case here. From whatever the circumstances, the facts of this case, that night, from what you heard from the stand from Mr. Rodriguez and what you heard on the videos from Josh, is like they got to a point where Josh is facing somebody between 6 to 10 feet. And he's telling that person, don't. Mr. Rodriguez tells him, what are you going to do with that thing? It's like, well, Mr. Rodriguez knows what's to be done with that thing. This is self-defense. Josh is pointing it. And he's saying, don't come closer. If you're going to do it, do it. Don't come closer. And then what happened. Those are not the facts of an individual who's out there intentionally wanting to hurt somebody. Because even from Mr. Rodriguez here, I did not believe he intended to harm me. That is why this is a case for mercy. This is not an evil person. This is not a person who's going to do something again and again and again. Listen to the context of that. If you go back, look at the video. When he's talking about, I'm going to do it over again and again and again, he's talking about protecting himself in that specific circumstance he felt himself under that day, that evening, where he felt from the conversation, from what was going on, that argument coming to those folks, he felt he had to fire the firearm. He felt he had to protect himself and protect his fiancée. What would the alternative have been? Is he dead? Is Katie dead? We don't know. What we do know is that Mr. Rodriguez is okay. There's no evidence of any complications. If there was any medical complications between May 22nd of 2020, you would have heard about them because you would have wanted to know, it's like, hey, this guy's still suffering from this or that. There's nothing there. He's moved on. The facts of this case call for mercy. The punishment you assess, that's the punishment that's going to affect Josh for the rest of his life. It's going to carry over. It's going to affect his now wife. It's going to affect his family. On that night, Josh made a decision. If he had not made the decision that he made to protect himself and his fiancée, what would that family be like? That would be the alternative. And now we're here before you, asking to be merciful. Josh did not want to hurt anybody. Look at his videos when he's out there with Melendres, when he's talking to Campbell. I did not want to hurt anybody. I did not want to hurt anybody. This is going to be continued. What we also have is, we know how society views convicted felons. They wear that scarlet letter. That's what they wear. That's what Josh is going to have to wear. One of the things that was very interesting to me was they found out that Rodriguez was a convicted felon. They found that out and they had that apprehension, like everybody else does. But their reaction speaks volumes as to that young man. He forgave. He's like, you know what? We all make mistakes. Everybody deserves a second chance. That's what they did. He welcomed him in and trusted him. That naive young man, this incident has changed him. If you send him to prison, he's changed. But if you send him to prison, society will gain nothing out of it. What is society going to learn by sending this young man with visual disabilities into a prison where he's going to come out, he's going to have the survival for him? It's going to change him completely. Punishment is continuous. It will continue to affect him. Probation is not easy. Many people are put on probation. And many people are put on probation for worse cases than this. There was questioning about guarantees. There is no guarantees in life. But people come into this court, they plead guilty for aggravated robberies, for sexual assault of children, and they are put on probation. They're allowed to go out into this community. Josh has been part of this community for the last 4.5 years, and there's nothing. So he's already been 4 years. You could put him on probation for another 10. You could be merciful. You could be merciful, just as Rodriguez is asking you to be merciful. I do ask you to go back and look at the words of a drunken man. Because they're going to get up and they're going to play that again. Oh, I'll do it again and again and again. And it's important to know the context of that. It's very important. We're asking you to be just. We're asking you to be merciful. And we're asking you to put Josh on probation. That's a decision you're going to make. And at the end of the day, possibly you're going to go home. Some of you might this might never come back into your mind. Some of you might find yourself thinking about what you did. Josh, his fiance, and his family are going to be affected by this for the rest of their life. You're allowed to be just, to protect the community by putting them on probation. He will be punished, he will be supervised. Do you think if Josh violates a condition of probation, that this prosecutor's, the DA's office is going to say, like, I know we got the first violation notice, we're going to let it go? But no, they're going to be all over that thing. And they're going to want to file a motion to revoke and sentence him to prison for whatever time you have determined to be just. Just like Rodriguez. He was on probation and he was revoked. He was on probation for an intoxication assault. Drove a vehicle while intoxicated. The vehicle is a weapon. And he injured his wife. Serious bodily injury. Rodriguez was given that opportunity to prove that he shouldn't go to prison. He was given justice to protect the community, to punish him, but he's given mercy, the opportunity to prove to you that he could be a productive member of society. In this case, he went to prison. We're asking you to be just. Give Josh that opportunity. Don't send him into a cage where he's going to come out and not be a member, contributing member of this community. Please, please, please be just. be merciful. Put Josh on probation. Thank you for your time, ladies and gentlemen.
May I have a 2-minute warning, Your Honor?
Pardon me?
May I have a 2-minute warning?
Yes, 2? Yes, ma'am.
Thank you.
I will be thine name, that king and come. That will be done on earth as we can have the day, that day, that against our trespasses, that came to the ghost, and trespass against us. We will shine and take their patience, but in the direction we for God is the kingdom, the power and glory forever and ever, Lord, you know.
JC recited the Lord's Prayer after he was shot, thinking he was going to die in an unknown apartment. The doctor told you he was less than 1 centimeter away from dying. This case is essentially less than a centimeter away from a murder. Now, it's very clear in this case that the victim was very religious. We know this because the conversation he had, we know this from his 911 call, we know this, he wears a cross around his neck. And we know that one of those tenets of Christianity is forgiveness. Defendant should not be given the benefit of choosing a victim who is forgiving. If anything, it makes his punishment more deserving. We also know that although there were a number of defense witnesses in this case, every person has a mother, and every person has things, people that are going to say very nice things about them. But ultimately, that doesn't matter, because they each, what our focus should be is not on the victim, on what he wants to have happen, but on what actually happened with the defendant, on the defendant's action. That should be our focus. It is absolutely natural that we want to show sympathy for different individuals, but our sympathy should be focused on the victim, not on the defendant. This defendant is just absolutely not a good candidate for probation. He doesn't think he did anything wrong.
I didn't do nothing wrong, and you know what? You give me the chance, I'd do it again and again.
He didn't show mercy to his victim. Why should we show mercy here and give him probation? The only way to prevent this from happening again is by sending him to prison. You heard from the probation officer. She cannot guarantee that his firearms will be taken away. She cannot guarantee to you that this defendant will not drink alcohol. And she cannot guarantee to you that this defendant will follow the law and not commit more crimes. You have a large amount of punishment range to work with here, anywhere from 2 years to 20 years in the Texas Department of Criminal Justice. In Neidhardt, we talked about a situation where the minimum punishment range might have been appropriate. And an example I gave was an individual who had a knife in their hand and scratched another individual. There are a lot of different types of deadly weapons that can be used in these kind of offenses. It could be a knife, it could be a beer bottle, all of these types of things. In this case, the defendant chose the most severe type of weapon, a firearm. We also know that that we can look at the seriousness of the injuries in this case. And that was something we took into consideration in determining where punishment should be. An example of a maximum range of punishment that we talked about was someone that did have a lot of criminal history. and had very serious injuries. So we have someone with lots of criminal history with a very serious case on one side, and someone with no criminal history and very minor injuries. So I would say to you that this case ends up somewhere in the middle, somewhere around 10. Due to the nature of the injuries, this being so significant that he almost died. But giving at the same time some mercy to the defendant because he didn't have much criminal history. So because of those two things, I ask that you look to the middle. Your verdict here today matters. People will open up newspapers. They will read online, potentially, what you did here today. What kind of message would you like to send to our community about what happens?
Proper argument.
Your Honor, it's proper argument, community caretaking.
Overruled. Carry on.
What kind of message do you want your verdict to send to this community? Is your verdict going to tell them it is okay to pull out firearms and shoot people? If you think that you might have a self-defense argument, is that what you want people to read? Because your verdict can make a difference in the community. It can change behavior in our community. We have enough people and enough times where people are at traffic stops pulling out firearms, at our businesses pulling out firearms, on our streets killing children and adults. Is the message that you would like to send to them that it's okay to do that, and when you do, you get probation? That is not just. We can give the defendant some mercy, but that means that we don't give him the maximum. That does not mean that we give him the minimum. I ask that through your verdict, you sign that last verdict form, and you sentence him to prison, and you do not give him community supervision, because you need to send a message to the community that we have had enough gun violence here, and we do not stand for that kind of behavior, and we do not want that in our community. Thank you.
Very good. Ladies and gentlemen, you now have all the evidence that you will receive in this case. You've heard the closing arguments, and you have your instructions that should be your guide as you go back and begin your deliberations. I'm going to pass this charge to the bailiff, and you may begin your deliberations. We will be in recess until you have a verdict. Thank you.
All rise for the jury.
Anything we need to take up?
No, that was the finish.
Okay, great. We're in recess. Well, come on over.
Okay, I've got it.
You got one? Ruby will take.
Oh, okay.
photos there. Well, you know, give her your phone too.
Okay. Let me, probably got some security
Yeah.
crap on it. Although my wife works in cybersecurity. I hear all of that stuff.
Okay, stand.
Oh,
stand.
okay.
Yeah. Face this way. If you raise your right hand. I, Gary D. Crane,
I, Gary Crane,
do solemnly swear
solemnly swear
that I will faithfully execute the duties
that I will faithfully execute the duties
of the office of Board Member, Texas Medical Board,
as in the office of Texas Medical Board as a member thereof,
Board Member,
board member.
that's right, of the state of Texas,
State of Texas,
and will to the best of my ability
and will to the best of my ability
protect, preserve, and defend
protect, preserve, and defend
the Constitution and laws
the Constitution and laws
of the United States
of the United States
and of this great state of Texas.
and of this great state of Texas.
So help me God.
So help me God.
Congratulations, Dr. Gray. Get a board member. That's right. You want to, let's get, no. You got cameras going? Yeah. Oh, good.
This way. All right.
One more review. We'll check. Yeah, yeah.
You ready? Okay.
We got that.
One more. Ready? And here we go. Got it?
All right. Well,
Yeah.
congratulations. Oh, well, thank you. Well, these, we're surrounded by such good people that make us look good. I'm sorry to make you wait. I didn't know what was going on, and we're running through this trial right now.
As a former hospital administrator, I've worked with nonprofits for that.
All right, and so how long ago were you appointed?
Till not to, 2007,
Okay, and when were you appointed?
this month, that first week.
Great. Well, thank you for doing this.
Well, it's been in the work since October.
Sure. Yeah.
Yeah.
Well, are you excited about it?
Oh, sure. I've already, scheduled setting down some cases.
Okay. So what is that board? It oversees disciplinary?
Yeah, licenses, disciplinary action. I know one.
Yeah, me too. Well, very good. And you went through the appointments process?
Yes.
Okay.
Yeah, maybe,
Sure.
School.
Oh, you did?
Yeah.
Right. You know, she went to Texas State.
Yeah,
Yeah, she's got some interesting stories from down here.
she does. I heard one from one of her buddies that was at.
Yeah. Well, I had this, should be the number here. Okay. Did you get his number?
Phone number?
So, 512, when you're ready. 512-917-6210. So it's. Which was.
University of Texas. Why is that a good name for a sooner?
I'm also.
Ah.
I got one master's.
Well, my dad is an Aggie. So, you know, he had to get over it when I went to law school at Texas. You know, the funny thing, I remember some guys from Texas A&M that went to school at UT.
Yeah.
They wore T-shirts that said Texas A&M School of Law, Austin campus.
You know, there is a Aggie.
Yeah, there is one now. When I was in school, there was not
Oh,
the
yeah.
Aggie school, but yeah, there is one now, and they're doing really well. I mean, they keep rising, and
I recommended a girl that she ended up being
Target,
Wow, you know how to recommend.
yes, great bartender.
How, whatever it takes, right? Thank you, Dr. Craig. Appreciate you doing this for us. I'll be in touch.
Okay. Officer himself.
Is your pots there?
Yes,
What kind are they?
these are the generic ones from Amazon.
Okay.
Okay.
Thank you.
And that's.
How are you?
What, the twins?
Yeah. Did you give me the wand table and stuff? I did not. I'll get to you today. We're putting on civil 2 weeks.
I got Burgess on Tuesday.
Oh, right. But we're gonna pick on the civil case. So we got 2 that are coming back.
Okay.
7 are set, 5 are set.
I mean, I try to come up whenever yours go anyways.
Right.
I'll be there.
Ready? Yep. Good man. All right, ladies and gentlemen, whatever the verdict is, please, no outbursts or anything. I don't know what it is myself. These people have given us their time and attention, given us a week. So please respect whatever that verdict is. That goes for both sides. Thank you.
All rise for the jury.
You may be seated. And with the floor person, please rise. I understand you have a verdict on punishment.
Yes, Your Honor.
Is it unanimous?
Yes, Your Honor.
Please pass it to the bailiff. The defendant, please rise. We, the jury, having found that the defendant, Joshua Patrick King, is guilty of the offense of aggravated assault as charged in the indictment, now return this verdict as to his punishment. 1, we assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 3 years. 2, in addition, we assess B, a fine of $10,000. 3, we find that the defendant has never before been convicted of a felony in this or any other state, and we make the following recommendations on his application for community supervision, probation. D, that the defendant's application for community supervision be denied. Signed, foreperson of the jury. Is there anything that anyone needs taken up with the jury?
Not from the state, Your Honor.
Defense? Very well, you may be seated. All right, ladies and gentlemen of the jury, I accept your verdict, and I thank you very much for your time. I know that y'all have given us your full week. You've worked very hard. You've always been here on time. We can't get justice in this county if we don't have people like you who come, listen to the evidence, and apply the law. So we really appreciate it very much. all of the instructions that I have given to you, the limitations, those are now lifted. So if there's anyone that you want to talk to about this case, you may. What that sometimes means is that attorneys, either the state or the defense, would like to ask you some questions. It's Friday, you don't have to stay and talk, but if you'd like to, realize that for them, this is a learning opportunity. The state will be trying another case in 2 weeks. These defense attorneys will try more cases as well. It's up to you though. Just understand that the requirements that I had on you are now lifted. So thank you very much for your time and service. I'll come back there and thank you myself as well. But I accept your verdict and I thank you very much for your service. Bailiff?
All rise for the jury.
You may be seated. Is there any legal reason we cannot sentence at this time?
Nothing to state, Your Honor.
Nothing to finish on.
All right. If you please stand, Mr. King. The jury having found you guilty and of aggravated assault with a deadly weapon, a second-degree felony, and the jury having assessed your punishment at 3 years in the Texas Department of Criminal Justice, the court accepts those verdicts and now sentences you to 3 years in the Texas Department of Criminal Justice. There will be a $10,000 fine. Is there anything else we need to take up?
No, Your Honor.
Just can we have a second?
Yes?
Your Honor, I have one other matter I would like to take up at this time. I have previously tendered to the state an exhibit, which is a certification of blindness for Mr. King. It will help with the Texas Department of Criminal Justice in assessing his disability under the Americans with Disabilities Act. We would ask that the court accept that as defense exhibit number 3 and include it in the record so that it will help facilitate things with the state of Texas.
Any objections?
No, Your Honor.
Defense exhibit. Let's identify this though, rather than DX3. How about post verdict? Defense exhibit 3,
That is totally acceptable.
just so that it's,
For clarification.
okay, so the court will accept PV DX3, post verdict defense exhibit 3, and that is accepted and will be added to the file. Yes? Yes, sir?
Yes, I read notice of appeal, Your Honor. No, I'm sorry. Is that the? Yeah.
Oh. Very good, Mr. King. I've received the trial court certification and am signing that. It will be added to your file. Anything else that we need to take up?
Yes, Your Honor. We'd like to be heard on a federal bond, Your Honor.
Okay, well, I'll come back and do that in a moment.
Thank you, Your Honor.
All right. I need to get the code out and direct me where the authority is on that.
Yes, Your Honor.
Okay. State, same thing. We'll talk about that. I'll be back shortly. Does anyone want to speak to them?
I would like to speak to the jury if they're willing.
Forty-four oh four B, Your Honor, specifically.
One moment, allow me to read it.
Yes, sir.
It's actually C.
Well,
I'm sorry?
well, the reason I was pointing to B because, well, if we're not, if we're fine.
It's B and C, Your Honor.
Yes.
You said 4404B?
Yes, Your Honor. 4404B. And Judge,
So is it just the absence of not being more than 10 years?
it's more than 10 years, Your Honor, and or being one of those enumerated offenses on 428-454A. This is not one of the enumerated offenses.
And
So
then,
he would qualify for, he would not be restricted from an appeal bond.
and under C, Your Honor, it's discretionary, and that's what's controlling in this situation.
Discretionary on good cause, Your Honor. There's a good cause standard.
Let's go on the record, Ruby.
Yes, sir.
Defense, you wanted to be heard?
Yes, Your Honor, we want to be heard with regards to an appeal bond, Your Honor, in this case.
Can I have you turn the mics up?
And you can both sit so that it is picked up by the
Yes, sir.
court reporter.
Your Honor, we would like to be heard on an appeal bond, Your Honor.
Okay.
And specifically, we've directed your attention to, section 4404B and C of the Code of Criminal Procedures, Your Honor. Mr. Price, does qualify for an appeal bond. And as is noted in section C, it is a may deny bail and commit the defendant to custody if there then exists good cause to believe that the defendant would not, one, appear when his conviction becomes final, that's when a mandate gets issued, or likely to commit another offense while on bail, Your Honor. This individual, Mr. King, has shown up for all his court appearances. He has been on bond for 4 years and 3 months, and there have been no new criminal offenses, Your Honor. There is no evidence, nothing that indicate that there good cause exists to believe that he would do so, Judge. Furthermore, you could impose reasonable conditions on that bond, and we would be willing to do a GPS monitor if the court was to set an appeal bond for Mr. Price from. Mr. King, I apologize.
State.
Your Honor, I believe in this case, good cause does exist to believe that the defendant is likely to commit another offense while on bail. We've heard over and over that he said he would do this again and again and again. And so due to the evidence that was presented during the trial and the defendant's own words, I believe that good cause does exist. If you do decide to grant him an appeal bond, we would ask for very stringent conditions, including drug and alcohol monitoring. We would also like GPS. We would also have him prohibited from having any firearms and any other conditions that the court deems appropriate. However, we do believe, because of the defendant's own statement, that good cause does exist to deny the defendant bond, and we are asking you to do so.
Since I'll give you the final word.
Your Honor, likely to commit a new offense. You yourself saw the video with regards to the context of that conversation, Judge. The individual you have here before you 4 years and 3 months later is not that individual. Those were the ramblings of a drunk man, Judge. He has learned so much. The naive, the happy-go-lucky, the friendly individual that you saw in that video is not who you have before you, Judge. Furthermore, I don't believe that his family is going to allow him to be in that position. As far as conditions of bond, we'll be fine with no firearms. We'll be fine with alcohol and drug testing. Judge, we'll be fine with GPS. There's nothing that would lead us to believe that he would commit another offense while he's out on bond, Your Honor. He didn't have any single offense prior for 20-some odd years and hasn't had anything since now, Judge. And he's been in the community without bond, without alcohol and drug monitor. So we ask that you grant an appeal bond in this case for conditions, if that's what the court wishes, Your Honor.
Very good. I'm gonna look at one other book. Give me 1 second. I want to see kind of a standard. Recess.
All right,
Maybe seated.
Your Honor, may I just offer two additional points, Judge?
Sure.
Your Honor, as you know, Mr. King is legally blind. He can get around in a car. He can drive. Any mode of transportation would require his father, mother, or wife to drive him around. He also lives out in the country, Judge, so it's not like he's gonna be going into the city or anything like that. Just wanted you to consider those two additional points, Judge.
Thank you. Were you able to get those from? They're on the way up.
Yes.
You know when they'll be here?
Right now.
The bond will be increased to $50,000. Defendant will be put on GPS monitoring. He will be limited to home, hospital, or church. If anything needs to change, he can apply for those things. No drinking, no drugs, no contact with firearms. You will report to pretrial services monthly. State anything you want to add?
Just no contact with the victim, Your Honor.
No contact with the victim. All right, anything else?
Your Honor, yes, actually, there is a $50,000 surety bond,
Cash, sure.
cash bond, cash surety.
Cash, sure.
Okay, thank you, Your Honor.
Okay, anything else?
Nothing with that, Your Honor. Thank you.
Yeah, Your Honor.
Okay, we're off the record.
Thank you, Your Honor.
Elect you, sir.
Thank you, Your Honor.
The judgment.
You want to talk to the jury?
I would.
From pretrial services. Hello, how are you? Good, thank you for coming up on a Friday afternoon.
Yes, sir.
Oh, that's okay. What we're gonna do is we're gonna have them on, pretrial service log.
There's pretrial services?
Yes.
In Brooklyn. They're the ones that do the pretrial, the GPS also, right?
Yes.
Okay, thank you.
Yes. Here's your GPS, he's limited to. Home, hospital, or church.
Is there going to be curfew time? Or I think it's standard. Hang on, okay.
Where all in the church or hospital.
Okay, and then is it gonna be paid by the county? Or is it gonna be paid by the county or by the county?
Drugs and alcohol monitoring.
Yeah.
No contact with firearms. 50,000 cash. And no contact with the victim, Juan Carlos Rodriguez.
We're trying. Well,